Welcome to LexTalks Legal Topics, simplified your companion for exploring the fascinating world of law. Today we're diving deep into the freedoms guaranteed by the Indian Constitution, specifically Article 19. We'll also be exploring the limitations on those freedoms, which is a crucial understanding for all of you law students in India. Okay, let's unpack this.
What's fascinating about Article 19 is that it's the cornerstone of individual liberties in the Indian Constitution. It's about ensuring citizens can express themselves, assemble, and even pursue their livelihoods without unnecessary restrictions.
It's like the bedrock of Indian democracy when you say it lays out these essential freedoms that allow us to fully participate in a democratic society. So to kick things off, can you remind us what those 6 core freedoms guaranteed by Article 19 are?
Absolutely. Article 19 guarantees Indian citizens 6 freedoms: the freedom of speech and expression, the freedom to assemble peaceably and without arms, the freedom to form associations or unions, the freedom to move freely throughout the territory of India, the freedom to reside and settle in any part of the territory of India, and finally, the freedom to practice any profession or to carry on any occupation, trade, or business.
Okay, that's a lot to digest. Let's break it down one by one. The freedom of speech and expression. That's a pretty big one, right? I mean, it's about being able to voice our opinions, write articles, create art, all those things that let us express ourselves.
It's even more than that. It's about the free exchange of ideas, dissent, and criticism, which are vital for a healthy democracy. Think about it. Without the freedom to express dissenting views, how can a democracy truly function? And the freedom to assemble peaceably. That's crucial for protests, demonstrations, and public gatherings, allowing citizens to engage in collective action.
Right, because if you can't gather and voice your opinions, how can you make your voice heard? Especially in a country as diverse as India, with so many different viewpoints.
Precisely. And that's where the freedom to form associations and unions comes in. Think of political parties, trade unions, student organizations, NGOs. All these groups rely on this freedom to organize and advocate for their interests.
It's interesting how these freedoms are all interconnected.
Yeah.
You can't really have a strong democracy without people being able to speak their minds, gather, and form groups to work toward common goals.
They absolutely reinforce each other. And then we have the freedom to move freely and reside anywhere in India. This allows citizens to travel, live, and work wherever they choose, which promotes national integration and economic opportunity.
It's like the Constitution is saying, hey, this whole country is yours to explore and make a life in.
Yeah.
And of course, we can't forget about the freedom to practice any profession or carry on a business. This ensures individuals can pursue their chosen livelihoods, contributing to the economy and their own fulfillment.
Exactly. It allows people to pursue their passions, develop their skills, and contribute to society in meaningful ways. Now, here's where things get really interesting. These freedoms, while fundamental, are not absolute. We can't just go around shouting fire in a crowded theater, right? So why is that? If these freedoms are so important, why are there limits on them?
That's a great question. It seems counterintuitive at first, doesn't it?
It does, but the reality is that sometimes the exercise of these freedoms can clash with other equally important societal interests. That's where the concept of reasonable restrictions comes in. The state can impose certain limits on these freedoms to protect things like national security, public order, decency, or morality.
Okay, reasonable restrictions. It sounds like finding that balance between individual rights and the needs of society.
Exactly. It's a delicate balancing act. The state can't just restrict these freedoms arbitrarily. There have to be legitimate grounds for doing so.
So who decides what's reasonable? Is there like a specific formula or test?
That's where the courts come in. They play a crucial role in interpreting Article 19 and determining whether a particular restriction is justified or if it's gone too far in limiting those fundamental freedoms.
So the courts act as a safeguard, ensuring that the government isn't overstepping its bounds and that these restrictions are truly reasonable. Can we delve into those specific grounds for restrictions? Because I know Article 19 gets pretty specific about when these freedoms can be limited, right?
Absolutely. For the freedom of speech and expression, Article 19.2 lists 8 grounds for reasonable restrictions: the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense.
It's interesting how they've really tried to think of all the different situations where freedom of speech might clash with other important interests, like the security of the state ground. That makes sense in theory. But couldn't it be misused to silence critics of the government?
That's a valid concern, and it highlights why the courts play such a critical role. They have to ensure that the government isn't using these provisions as a way to suppress legitimate dissent or criticism.
It's about making sure that the power to restrict these freedoms isn't abused. So How do the courts actually decide if a restriction is reasonable? Do they have a checklist they go through?
It's not exactly a checklist, but there are a few established tests that have come out of landmark judgments. First, the restriction has to be imposed by a law passed by the legislature. It can't just be some arbitrary executive action.
So even if it's for something like national security, it can't just be a spur-of-the-moment decision. It has to be grounded in an actual law passed by the legislature.
Precisely. This principle was highlighted in the case of Ramesh Thapar versus the state of Madras. It's a fundamental safeguard against arbitrary government power.
That makes sense. It ensures that there's a process and that these restrictions aren't imposed lightly. What are the other tests the courts consider?
The second test is that there must be a clear connection between the restriction and the objective it's trying to achieve. The restriction can't be some random measure. It has to be directly relevant to addressing the issue at hand.
So, for example, if the government wants to restrict speech that incites violence, they can't just ban all public gatherings. They'd have to show a specific link between the speech they want to restrict and the potential for violence.
Exactly. The courts would scrutinize that link very carefully. The case of Bangalore Medical Trust VBS Madappa illustrates how this principle works in practice.
So it's about being very specific and targeted with these restrictions. You mentioned there was a third test. What's that one?
The third and perhaps most crucial test is that the restriction must be reasonable and proportionate. This means it shouldn't be excessive and should be the least restrictive means of achieving the desired objective.
So like using a scalpel instead of a sledgehammer.
Perfect analogy. If the government can achieve its goal, say protecting public order, with a less drastic restriction on freedom of speech, then using a more severe restriction would be considered unreasonable. This principle was established in Maneka Gandhi versus Union of India.
This case is really fascinating. I remember studying it in law school. It significantly broadened the scope of Article 21, the right to life and personal liberty, and really impacted how we interpret reasonable restrictions today.
It's a landmark case for sure. What's particularly noteworthy is how the court emphasized that the procedure for restricting a fundamental right should be just fair and reasonable. This ensures that individuals aren't arbitrarily deprived of their freedoms.
It adds another layer of protection, ensuring that the process itself is fair and just.
Right.
Now, these tests mainly focus on the freedom of speech and expression. Do the same tests apply to restrictions on the other freedoms in Article 19, like the freedom to assemble or form associations?
The same general principles apply, but the specific grounds for restrictions might differ depending on the particular freedom being restricted. For instance, the freedom to assemble peacefully guaranteed by Article 19(1)b can be restricted in the interest of the sovereignty and integrity of India, the security of the state, or public order.
So the focus isn't on whether the government agrees with the message of the assembly, but rather on legitimate concerns about public safety or national security.
Exactly. The state can't prohibit a protest just because it disagrees with the protesters' views. It has to demonstrate a real and imminent threat to public order or national security.
It has to meet that threshold of a genuine threat, not just a dislike for the message. What about the freedom to form associations protected by Article 19(1)c? What kind of restrictions are permissible there?
Article 19(4) allows for reasonable restrictions on this freedom in the interest of the sovereignty and integrity of India public order or morality.
So you can't form a group that promotes violence or illegal activities. But you also can't be prevented from forming a group just because the government disagrees with your political views.
That's right. The restriction must be justified based on a legitimate threat to public order, morality, or national security, not simply on the basis of the association's ideology.
It's all about drawing that line between legitimate restrictions and those that infringe on the fundamental right to form associations. The courts really are the gatekeepers of these freedoms, making sure that the restrictions are justified and not used to unfairly suppress our rights.
They are the guardians of the Constitution, ensuring that the balance between freedom and restriction is maintained. It's a complex task, but a vital one in a democracy.
Speaking of landmark judgments, could you give us some specific examples of how these tests are applied in real cases? I think that would be helpful for our listeners who are aspiring lawyers.
Absolutely. Let's start with State of Madras versus V.G. Roe. This case is crucial because it established a key precedent for how courts determine the reasonableness of a restriction. The court had to decide whether a law requiring licenses for processions was a justifiable restriction on the freedom of assembly.
That's a real-world scenario that could affect any of us if we wanted to organize a protest or a march.
Exactly. And the court's decision set forth some key principles that still guide judicial decisions today. They emphasize that the restriction must be based on the specific grounds outlined in Article 19, not some vague or arbitrary reason. They also stress that the test of reasonableness must be applied to each individual statute, meaning there's no one-size-fits-all approach. Each case has to be judged on its own merits.
So in that case, did the court think the licensing requirement was reasonable? Or did they think it went too far?
They actually found that the licensing requirement was too broad and gave the authorities excessive discretion, which could easily be misused to suppress legitimate assemblies, so they struck down that part of the law.
So that's an example of how the courts can protect our freedoms from overly broad restrictions. It's reassuring to know that those safeguards are in place. Do you have any other examples? Maybe one that deals with the freedom to carry on a business?
Absolutely. Sagir Hamad versus State of UP is a classic case that illustrates the tension between individual economic freedom and state control. It involved a law that essentially gave the state a monopoly over certain transportation routes. The question was whether this was a reasonable restriction on the right of private operators to run their own businesses.
It seems like a tough case trying to balance those competing interests. What did the court decide?
In this case, the court sided with the individual. They held that the restriction was arbitrary and unreasonable because it completely deprived private operators of their right to carry on their businesses.
So even when the state claims to act in the public interest, the courts can step in and say, hold on, this is going too far.
Exactly. They have a duty to protect individual freedoms from excessive government interference, even when the government claims to have good intentions. Now, for a slightly different example, let's consider Indian Express Newspapers v. Union of India. This one involved taxes on newsprint, which, as you might imagine, has a significant impact on the freedom of the press.
Taxes. How did taxes relate to freedom of the press?
Well, think about it. If the government can impose heavy taxes on newsprint, it can effectively make it impossible for newspapers to function, essentially limiting their ability to publish and circulate information.
Right. The financial burden of those taxes could cripple a newspaper. What did the court decide in this case?
The court actually upheld the import duty but struck down the auxiliary duty, saying it was excessive and went beyond reasonable limits. They emphasized that while the government has the power to tax it, it can't use that power to stifle fundamental freedoms, like freedom of the press.
So even when it comes to taxation, there has to be that balance. The government needs revenue, but it can't use taxes as a weapon to suppress our freedoms.
Precisely. And the courts are there to ensure that balance is maintained. It's a constant back and forth, but a necessary one in a democracy.
It's fascinating how these cases show the real-world impact of Article 19. These aren't just abstract legal concepts. They're principles that are constantly being debated, interpreted, and applied to protect our freedoms. But before we wrap up this part of our deep dive, I have a question. We've been talking about the freedoms of Indian citizens, but what about non-citizens living in India? Do they have any protection under Article 19?
That's an important point. Article 19 is specifically for citizens of India. Non-citizens, while not covered under Article 19, are still entitled to certain other fundamental rights.
Which ones? I think that's important for everyone to know.
For instance, Article 14, which guarantees equality before the law, and Article 21, which protects the right to life and personal liberty, are applicable to everyone in India, regardless of their citizenship.
So while non-citizens might not have all the freedoms listed in Article 19, they still have basic human rights protections under the Indian Constitution.
Yes, and those protections are crucial for ensuring a just and equitable society for everyone living within its borders.
That's an important point to remember. Okay, that's a good place to pause for now, Janice. We've covered a lot of ground, but there's still so much more to explore about Article 19. We'll continue our exploration in Part 2.
Welcome back to LexTalks. We just finished exploring those 6 fundamental freedoms guaranteed to Indian citizens under Article 19 of the Indian Constitution, along with the reasonable restrictions that can be placed on them. Now let's dive into the remedies available if your fundamental rights are ever violated.
Yes, this is where the rubber meets the road. It's great to know about these freedoms and their limitations in theory, but what happens if someone actually tries to infringe upon your rights? What can you do about it?
That's where the real power of the Constitution comes in. It's not just a theoretical document. It provides actual mechanisms for enforcing these rights. And a primary avenue for seeking redress is through writ petitions.
Writ petitions, for our listeners who might not be familiar with the term, are essentially legal documents you can file in a high court or the Supreme Court if you believe your fundamental rights have been violated.
Precisely. Article 32 of the Constitution specifically empowers the Supreme Court to issue writs for the enforcement of fundamental rights. And Article 226 gives similar powers to the high courts.
So you have a choice. You can either approach the High Court in your state or go directly to the Supreme Court. It seems like the Constitution really wanted to make sure citizens had avenues to protect their rights.
It highlights the importance the Constitution places on safeguarding those rights. It's not just about stating those rights, it's about providing the means to enforce them.
It's like having a safety net, knowing that if your rights are violated, you have recourse. Okay, so let's say someone believes their freedom of speech has been violated. They can file a writ petition. But what exactly is a writ? It sounds a bit archaic.
Think of it as a command from the court. There are 5 types of writs that can be issued: habeas corpus mandamus, prohibition, certiorari, and quo warranto.
Wow, those are some impressive legal terms. Can you break those down for us? What are they, and how do they relate to protecting fundamental rights?
Let's start with habeas corpus. This writ is a cornerstone of personal liberty. It literally means you shall have the body, and it's used to challenge illegal detention. Imagine someone is imprisoned without a proper trial or justification. Habeas corpus can be used to demand their release.
So the court can demand the authorities bring the detained person before them and justify the detention. And if the detention is unlawful, the court can order their release.
Exactly. It's a vital safeguard against abuse of power, especially in situations where there are concerns about police brutality or arbitrary arrests.
It ensures that no one can be deprived of their liberty without due process. It's a powerful tool. What about mandamus? What's that one all about?
Mandamus is used to compel a public authority to perform a legal duty. Let's say a government official is refusing to do something they are legally obligated to do. You can file a mandamus petition to force them to act.
So if you've been wrongfully denied a license to practice your profession, for example, you could use mandamus to compel the licensing authority to issue the license. It sounds like a way to hold those in power accountable.
Exactly. It ensures that public authorities don't shirk their responsibilities and provides individuals with a way to address bureaucratic roadblocks. Now on to prohibition. As the name suggests, it's used to prevent a lower court or tribunal from exceeding its jurisdiction.
So if a lower court is trying a case that it's not authorized to handle, a higher court can step in and say, no, you're overstepping your boundaries. It's a way to ensure that legal proceedings are conducted fairly and by the proper authorities.
Precisely. It's about maintaining order and fairness in the judicial system. And that brings us to certiorari. It's similar to prohibition, but it's used to quash an order that's already been passed by a lower court or tribunal.
It's like hitting the undo button on a court order.
That's a great way to think about it. If a higher court finds that a lower court's order was flawed or issued without authority, it can use certiorari to overturn that order. It's a crucial check on the lower courts.
So in essence, these writs act like safeguards, ensuring that the judicial process is fair and just. We've covered 4 of the 5 writs. What's quo warranto all about?
Quo warranto is an interesting one. It literally means by what warrant, and it's used to challenge someone's right to hold a public office. If there are doubts about someone's qualifications or legitimacy in holding a specific position, this writ can be used to investigate and potentially remove them from that office.
It's like a way to hold public officials accountable and ensure they're rightfully entitled to their positions. It's a powerful tool for upholding integrity in public office. So these writs provide individuals with legal tools to protect their fundamental rights and challenge unlawful actions by authorities. They are essential for seeking justice and holding those in power accountable.
You've hit the nail on the head. Understanding these writs, how they work, and when they can be used is essential for any law student in India.
It's not enough to just understand the theory of fundamental rights. You need to know how to defend them in real-world situations. And these writs provide the mechanisms to do just that.
Exactly. It's about bridging the gap between theory and practice.
Okay, before we move on, I want to clarify something. You said both the Supreme Court and the high courts can issue these writs for fundamental rights protection. So what's the difference? When would you approach one versus the other?
That's a key question. Generally, you would approach the high court in your state first. They're the initial point of contact for most legal matters, including those related to fundamental rights.
So you start with the high court, and if you're not satisfied with the outcome, you can appeal to the Supreme Court. It sounds like a hierarchical system with the Supreme Court acting as the final arbiter.
Exactly, but there are certain circumstances where you might go directly to the Supreme Court. For example, if a case has national implications, or if there's an urgent need for intervention, you might bypass the High Court and go straight to the Supreme Court.
So it depends on the specifics of the case and the level of urgency involved. It seems like having a good lawyer to guide you through this process would be invaluable. They could advise you on the best course of action based on your circumstances.
Absolutely. Navigating the legal system can be complex, and having expert guidance can make all the difference. Now, are you ready to move on to our next key point?
Definitely. It's been fascinating to learn about the different ways individuals can seek redress if their fundamental rights are violated. But I'm curious to see how all of this comes together in real-world situations. Let's explore that further. So we've covered a lot of ground in our exploration of Article 19, from the 6 core freedoms it guarantees to the reasonable restrictions that can be imposed on them, and even the legal remedies available if those rights are violated. It's been a fascinating journey through the complexities of this cornerstone of the Indian Constitution. But I think what's missing is that connection to real life. How do these principles play out in actual situations? Can you give us some examples of how Article 19 has been used to protect freedoms in India?
Absolutely. Article 19 has been at the heart of countless landmark judgments that have shaped the legal landscape in India. It's been invoked to safeguard everything from freedom of the press and artistic expression to the rights of workers and marginalized communities. It's a testament to its enduring relevance and power.
Okay, let's get specific. What are some cases that stand out as powerful examples of Article 19 in action?
One of the most significant cases involving Article 19 is Vishaka v. State of Rajasthan from 1997. This case was a turning point for women's rights in India, specifically addressing the issue of sexual harassment in the workplace.
I remember studying this case in law school. It was a groundbreaking judgment. But how did Article 19 come into play in a sexual harassment case?
The court creatively used Article 19(1, the right to practice any profession, as the foundation for their decision. They argued that sexual harassment creates a hostile work environment, which directly impedes a woman's ability to work with dignity and equality.
So they linked the right to work with the right to be free from harassment. It was a powerful interpretation of Article 19.
Indeed. And it led to the development of the Vishaka Guidelines, which established a framework for preventing and addressing sexual harassment in workplaces across India.
That's incredible. So Article 19 wasn't just about safeguarding someone's right to have a job. It was about ensuring they could exercise that right in a safe and respectful environment. It shows the court's willingness to adapt constitutional principles to address evolving social issues.
Exactly. It demonstrates that the Constitution is a living document capable of responding to contemporary challenges. Now, shifting gears, another compelling case is Shreya Singhal v. Union of India from 2015. This case dealt with Section 66A of the Information Technology Act, which was being used to arrest people for posting allegedly offensive content online.
Oh, I remember that case. It sparked a huge debate about freedom of speech in the digital age.
Yes, it was a landmark case for internet freedom. The petitioners argued that Section 66A was overly broad and vague, giving the government excessive power to censor online speech, thereby violating Article 19A, the freedom of speech and expression.
They were essentially arguing that the internet should be a space where people can express themselves freely, just like in the offline world.
That was the heart of their argument, and the Supreme Court agreed, striking down Section 66A as unconstitutional. They held that it didn't fall within the reasonable restrictions allowed under Article 19(2).
So it was a victory for freedom of expression in the digital age, ensuring that our online spaces are protected by the same constitutional guarantees as our offline spaces.
Precisely. It was a crucial step in recognizing that freedom of speech in the 21st century extends to the digital realm. It also demonstrated the court's willingness to protect online speech from government overreach.
It's fascinating how Article 19 can be applied to such a wide range of situations, from offline harassment to online censorship. Are there other areas where Article 19 has had a significant impact?
Yes, Article 19 has also been crucial in protecting the rights of marginalized communities, particularly regarding freedom of movement and residence. A prime example is the case of State of Uttar Pradesh v. Kaushalya, which involved the movement and residence of sex workers. In this case, the court upheld certain restrictions, citing concerns related to public health and morality.
That sounds like a complex case. How did the court balance individual rights with these public concerns?
The court recognized the significance of safeguarding public health and safety, but emphasized that any limitations on individuals' freedom of movement and residence must be reasonable and proportionate. They also highlighted the importance of considering the rights and vulnerabilities of marginalized communities.
So the court was acknowledging that even sex workers, often stigmatized and overlooked, have fundamental rights under Article 19.
Yes, it's a powerful example of the court applying the principles of reasonableness and proportionality, even in cases dealing with sensitive issues and marginalized groups. It reinforces the idea that the Constitution's protections extend to all.
These cases are incredibly insightful. They show us that Article 19 is a dynamic force constantly evolving through judicial interpretation to address real-world challenges. But I have to admit, interpreting and applying Article 19 doesn't seem easy. There's a lot of nuance involved in balancing individual rights with societal interests.
You're absolutely right. It's not a simple black and white issue. There's often tension between competing interests. And it's up to the courts to carefully weigh those interests and find a balance that upholds both individual freedoms and the common good.
So it's not about blindly defending individual rights, no matter the cost. It's about finding a solution that respects individual freedoms while also considering the broader societal context.
Exactly. The Constitution acknowledges that limitations on individual freedoms might be necessary to protect other vital interests, like national security, public order, or the rights of others.
It's like that saying, your freedom to swing your fist ends where my nose begins.
That's a great way to put it. It highlights the delicate balance that Article 19 is constantly trying to strike.
So what does this all mean for our listeners, especially those aspiring law students? What's the key takeaway from our exploration of Article 19?
The biggest takeaway is that Article 19 is a dynamic and constantly evolving area of law. It's not just a set of fixed rules, it's a framework for navigating the complex relationship between freedoms and restrictions in a democratic society. Understanding it requires more than just memorizing the text. It requires critical thinking analysis and a deep appreciation for the values that underpin the Indian Constitution.
It sounds like a fascinating and challenging field of study. For all you aspiring lawyers out there, the world of law is full of intriguing issues and opportunities to make a real difference.
And remember, Article 19 and its limitations are constantly being shaped by court decisions, so staying informed and engaging in thoughtful debate is vital.
Thank you for listening to LexTalks. Follow, subscribe, and stay notified to never miss an episode. We'll see you in our next deep dive.